going to start today talking about an important case. It's a spousal support case, and we have none other than Victoria with us, who's taken the time to read this and be able to discuss it so that our viewers can get the cutting edge of the law as it applies to spousal support. And I will say that I believe this is the most recent appellate court decision on spousal support since it was just published in 2022, and I didn't find any other ones that were published that, at least that were meaningful. So, Tori, can you explain what the topic would be, first of all? Now, this I think it was like, I don't know if this was 35 pages. I mean, it was a very lengthy appellate court decision, and I'll say this for those of you who may want to look at it, what's the case name?
In Marriage of Zucker.
Marriage of Zucker, okay. And in this case, what you should know is that there's a unpublished portion of the judgment, there's a published portion, and then there's another unpublished portion. And, unless you're an attorney, you probably don't need to know too much about it other than we're just going to be focused on the published portion because that's the citable portion. That's something that we could cite in an appellate court brief if we felt that this court would help our clients. The rest of the stuff is kind of good for learning. It's kind of good for knowing about different issues and everything, but it's not something we're going to cite or even talk about today. So what's the main topic of the case?
Well, the background is that there is a premarital agreement that these parties are contesting, essentially, and then specifically the provision that is, looked at very closely by the case is the spousal support provision.
Okay, so somebody's contesting the enforceability of a premarital agreement, and the trial court made rulings, and the appellate court is making a ruling on the trial court's rulings. So why don't we talk about, the parties in this case? I think the way to start off about this is describing who they are, right?
Yeah. So we have a husband and wife, as we usually do in a premarital agreement setting. And again, like we usually have in a premarital agreement setting, one party kind of advocating for the premarital agreement, one party who claimed they were reluctant to enter into it, but they felt they had no choice, so they signed. Mom kind of has a rougher background than father, will say. She claims she has some psychological issues, some emotional and mental health issues. She doesn't really have a long history of working. She attended a few college classes, but never finished college, so high school education. Whereas father is this, wealthy. He runs hedge funds, I understand, and there's a significant disparity in the incomes. I mean, when she enters into the marriage, is basically receiving money from her mother, hasn't worked, but father is bringing in, I can't remember his net worth at the beginning of the marriage, but I think it was close to $25,000 a month. I mean, it was very significant.
Yeah, and it grew throughout the marriage. So one thing we should pause at is when people come to us for premarital agreements, one of the first question I ask is, when is the wedding date? Mm-hmm. Because if they're coming to me like right on the eve of the wedding, it's like, I'm sorry, but I can't do it for you. There's some strict laws with regard to when a premarital agreement has to be completed. And quite frankly, jumping in on a premarital agreement right before the wedding is a recipe for malpractice because there's so much room for error. That wasn't this case where that happened. But I always ask one question after that. Mm-hmm. I say, who wants it more? Mm-hmm. Who really wants this premarital agreement? On a rare occasion, well, we both want it because, and they don't even know why they want it. They just think that's a smart thing to do. But most of the time what happens is people come in and they say, he wants it. Mm-hmm. He wants it because he's got mega dollars. He's got, it comes from a very wealthy family. I hear a lot of times that it's the family is making him do that. Mm-hmm. And other times, he really wants it. He won't marry me, and that type of thing. On occasion, somebody comes in and says, I'm the one that wants it,
right?
And stuff. So here we've got, I think you've already described, pretty well, is you've got a man who is like filthy rich, right? And he only gets richer during the marriage, right? By the time that these people divorce, I mean, this guy's like, he's a multi-millionaire, very, very wealthy. She, on the other hand, has got legitimate issues. Mm-hmm. And the Court of Appeal recites some of those facts with regard to that. Mm-hmm. So continue on.
Basically, the trial court and the Court of Appeal are looking at whether or not it was unconscionable at the time of enforcement, and specifically they're looking at the spousal support provision, which, as you mentioned, I mean, the husband goes on throughout the marriage and just drastically increases his income. And I think the specific provision, it caps her spousal support about $6,000 after a marriage of, I think it was over 2 years. I can't remember the exact length, but nonetheless, they have a long-term marriage, and it's capping the spousal support provision at $6,000.
Which was the terms of the premarital agreement.
Right,
It was like,
right.
okay, this is how it's going to be.
Yeah.
And you're right. Now, how many children do they have?
They have 6 children.
Okay, so here's this woman. She doesn't have a large earning capacity. She's got emotional issues. She enters into the marriage, agreeing to sign the premarital agreement, and she ends up 6 kids, and they're divorcing, and he basically lives in mansions, drives Rolls Royces. I'm just exaggerating here, making this up, but he's got his own yacht. And she's living in a very, very humble situation, and so she doesn't like the enforceability of this agreement. Right. So, continue.
So essentially, the Court of Appeals says, you're right, this is unconscionable at the time of enforcement, and I think they invalidate that particular provision of the premarital agreement based on the fact that it was unconscionable at the time of enforcement, not necessarily the time of execution.
Okay, now this is where we get into the legal wonky stuff here. And so before we started filming, I told Victoria that I'm sorry for asking her to help me with this case, because unless you've actually tried a case on the enforceability of premarital agreements, you may not know about the history of them. And so let me just go through that really fast. Premarital agreements haven't always been favored under California law. In fact, there was a long period of time when they were disfavored. They were ruled to be against public policy. And then there became an awakening within California, and the legislators started changing the law. Courts of appeal started changing decisions, shaping public policy about premarital agreements. And I think that probably coincided with women entering the workforce, women being allowed to go to school, becoming, equal citizens in this world, and so, there was a movement, and there has been a movement recognizing the enforceability of spousal support provisions within a premarital agreement, or just premarital agreements in general. So, what happened is that there's been various changes to the law, and knowing what those changes were during certain time periods can be important if you're handling a premarital agreement case. I had a case where we were litigating the validity of a premarital agreement that happened the parties entered into in like 1988. And that law was pre-marriage of Pendleton, which was discussed in this case. I mean, it was really early on. So what we had to do was look at the laws that existed then and judge the validity of the premarital agreement as of that time period. So there's been 3 or 4 significant changes in the law with regard to that, and not all of the provisions are retroactive. So like, in I don't know if it's 2022 or whatever it was, there were some changes. The Fellows decision decided that, not everything is retroactive. One of the recent changes in premarital agreements is saying that the court may determine the validity of a premarital agreement based upon the unconscionability at the time of enforcement. In other words, when the parties are divorcing. So at the time that they signed into it is not really, it doesn't matter. You don't have to look at that. You got to look at the current situation. Are we going to enforce the spousal support provision knowing what we know now 20 years later with these parties in their current situation? That was the law. The Fellows decision said, yeah, but that's not retroactive. Okay, so that put many of us on the thinking that unless it was pre-modification, that those prior premarital agreements, you had to judge it at the time of signing the agreement, not at the time of current day. Wow. And so that's how we've all been operating. Well, this court decided differently, right? Why is that?
So they look at the Pendleton case, as you said, and it says, even though, and this is like very nuanced, like you said, and lots of legalese here, but
well, let me jump in. I think really what the essence is that, yeah, we modified it, but we didn't mean to change things that, like that here. I mean, the pre-existing law under Pendleton was that the court can determine whether it's unconscionable at the time of the divorce. Right. And when we said that, Fellows says it's not retroactive, well, that's true, but we didn't have to change things with regard to that, and stuff. And I think there was some accidental confusion when they said that, at the that unconscionable at the time of enforcement is a new law, where in fact it was an existing law, is really what it was. Yeah. So here's some portions of the decision that I thought were kind of meaningful. One of them says, in light of the importance of the right to spousal support in appropriate cases, we see no reason why, as a matter of public policy, a premarital agreement entered between 1986 and 2002, which is when they had amended the code, waiving or limiting the right to spousal support ought not be examined by a court for unconscionability at the time of enforcement. So that's kind of the holding, that's kind of the rationale. And it goes on to say, thus, despite the non-retroactivity of Section 1612, subdivision C, and of course the Fellows decision as well, we hold that the court retains the power under Section 1612 to shape public policy regarding premarital spousal support agreements to the extent not inconsistent with the legislative declarations. So they did a search of the legislative intent when in 2002, and they found that there was no intent to preclude that type of a thing. That a premarital spousal support agreement is unenforceable as against public policy solely because it is unconscionable at the time of enforcement. And in the instant case, therefore, the trial court did not err in considering whether the spousal support provision of the PMA was unconscionable at the time of enforcement. So, again, this is a very wonky decision. You could take days to read this thing, and it's basically a decision that is great for a law review article, or something to kind of get kind of some history on it, but it's not necessarily something we want to spend 30 minutes going through. But I think that a couple of lessons that I learned. One is that the courts shape public policy in this thing. That struck me with that phrase, that the court has a license to shape public policy, because that's how it's always been. And you hear a lot of people say, well, judges shouldn't be legislating from the bench, right? And I wonder sometimes if it depends on, who's the one that's writing that decision, shaping public policy. I'm not necessarily against this decision, but I found that to be interesting, that apparently that's always been part of the process. The other thing that I thought is my God, this is going to cause a lot of litigation.
Right.
There's a lot of divorces that we're doing now with baby boomers, gray divorces, and those people are the ones that have entered into premarital agreements prior to 2002. When I think about this now, every time we have a divorce where there's a premarital agreement, regardless of when it was signed, we need to be talking about this, right? Yeah.
Also, just in terms of, advising clients when they're entering into a premarital agreement.
Yeah, good point.
That, this is going to be looked at not just at execution, or possibly it's going to be enforcement as well, perhaps. So there's some complications that exist there. I mean, marriages are long and a lot can happen in the time of a marriage. So I think that it also creates some complications when you're advising clients about entering into a premarital agreement,
Yeah, I do make it a habit. I hope that I do this every single case, but I try to by telling them, just because you have a premarital agreement doesn't mean, number one, that it's going to be enforceable, because you never know what a judge will rule or something like that. We believe that most of them will be deemed enforceable if it's done right, but also it isn't necessarily going to save you money, because of the fact that I've seen people spend hundreds of thousands of dollars litigating over the validity of a premarital agreement. It could actually cost you more money because you're fighting over the terms of that thing. Again, I'm not saying I'm against premarital agreements, because I do think that they have their place. But that's just further. Now we've got to tell clients, guess what? That spousal support provision, it's not as strong as you think, right? What are, I'm going to confess, prior to this appellate court decision, I've been telling people that we don't know what it looks like unconscionable at the time of enforcement. Because when I saw the amendment, and I've never seen an appellate court decision say, aha, because this is the first one. This case, this was unconscionable. We're not going to allow the trial court to enforce this one. This is the first one. Because I've been like, what does it mean? What is unconscionable? Is it a case where the mother has to be literally in the streets? Father is, living in Beverly Hills, smoking a pipe? What is it? And it gives a little bit of clarity here.
Yeah.
But what do you think about that?
I felt like the case didn't discuss in very detailed about why they were terminated. It was unconscionable. I mean, they have a little snippet there that they talk about, she waived her community property interest. She's only getting $6,000 in support. And here's dad. It says he's making $250,000 a month, and she's taking home $6K. I mean, that's just oppressive, they say, and that's kind of the word that they use is oppressive. And again, I think they could have clarified more as to why it was unconscionable, but they were really just focusing on this mass disparity that was existing. And certainly she wasn't homeless, but given his ability to provide more support, they felt the provision was, I guess, again, oppressive is the word they use.
Interesting, very interesting. Now, let's make it clear is that this premarital agreement was not deemed unenforceable because the wife didn't agree to sign it. I mean, in fact, she agreed to this, and she apparently had said, I'll sign whatever you put in front of me. And she did so knowingly and intelligently. The question was it a fair thing, and what's kind of interesting, they really focus a lot on the big picture, looking at what was going on before they signed it and then afterwards, but I didn't know that there were other appellate court decisions that weighed in on the unconscionability at the time of enforcement. But what they did is they looked back, and there were some other cases like the Factor case, which I wasn't aware of there. So there's some guidance. If we get a case like this, we should be looking and saying, okay, can we argue? Wow, I mean, it's not uncommon that we'd be representing somebody that's got mega bucks, and they have the most tightest, strongest premarital agreement in the world and stuff, but there's going to be litigation. I know, I just feel it coming.
Yeah.
So, good decision to hang on to, Was there anything else about this decision that caught your fancy?
I mean, like you said, it's such a lengthy decision, and there's a lot in the unpublished portion, which we're not speaking about, but, certainly just the fact that they didn't give a lot of weight to the background. I mean, they discuss it, right, the background of the mentoring to the premarital agreement, but I thought the court actually was making a good policy decision and not giving a lot of weight to the circumstances, just in the sense that, that's a slippery slope, right? If we're always, and I'm referring, I guess I'm talking in the air a little bit, but, the terms that she said, I only signed this because if I didn't, I was going to have this abortion. And I thought the court was wise to stick to the undue influence, the duress, the factors that already exist, and really not invalidating the premarital agreement just on the fact that she felt forced into it, in the sense that she only had two options. The court said, well, you still entered involuntarily. And I know you didn't want to get too much into the weeds on that, but I did think that was interesting that the court they highlighted it, but they ended up not siding with mother on that.
Right. They just said that the disparity.
Right.
She had emotional issues, and then the disparity of the income and stuff. She's basically a very unstable person.
Right.
And
only comment because I thought that's the direction initially the court was going to go, is saying and giving a lot of discussion to that. But I was surprised they didn't. They said, well, still it was voluntarily. It was a voluntarily entered into premarital agreement. It was just unconscionable
to enforce it now.
Right.
Wow. That's like bringing back spousal support back in time, and stuff to say that, or actually going back in history where they were disfavored almost. It's like is it keeping up with society? I wonder.
Yeah.
I don't know, but all I know is that there's going to be a lot of litigation, and if there's not litigation, people are going to be settling now, and saying, okay, I wasn't planning on paying you anything, but guess what? I'm going to have to pay you something because otherwise we're going to find ourselves in court having to litigate this stuff.
Yeah, I wonder if you'll see people be more reluctant to enter into premarital agreements, or if they'll just not carry the same weight because...
Interesting thought, too, because, the person that wants the premarital agreement has to be told about this decision and stuff, and maybe it's not worth it to them anymore. I don't know. Maybe if that was their only issue. I mean, premarital agreements can change community property law in a lot of different ways, right? But if the only thing they're trying to do is not pay spousal support, that has to come with a strong warning.
That raises another question, right? Are we going to look at unconscionability at the time of enforcement with respect to community property rights? I mean, they didn't do that in this case. It was just spousal support, but is there going to be any issues with the other provisions that we typically see in?
I don't think so.
Just spousal support.
Yeah, because because that's etched in the law. Spousal support is
More discretionary.
It's when I started family law, I said, okay, and I started family law as a family law practitioner back in probably like 2002 or 2001 or something like that. Come from the DA's office, and I'm like, isn't spousal support kind of an arcane statute? I mean, it seems like women are working as much as men. Women are making money now. It seemed unfair to me that women file for divorce 70% of the time. And so I'm going to file a divorce against you, and guess what? You're going to pay me for 10 years or 20 years for spousal support. How do you like that? Yeah, but you were, you were mean to me, and you were seeing another man. It doesn't matter. You're going to be paying me spousal support. I just saw that as being, and by the way, I've got a college education. Of course, I'm not working, but, I could work. All those thoughts were coming through my head, and I'm like, why is this fair anymore? I mean, I could see back in the 1800s when people, women didn't work at all. They had 12 kids, and the guy went out and made something of himself, and she and the kids were in the streets while he's, traveling the world or whatever. I could see it back then, but I couldn't see it in 2002. Here's what I did, though, is I really, really did some research and read law review articles, and I've come to this, is that spousal support is kind of a property right in a way. If a spouse is staying at home to support the household and the kids while the other spouse is advancing in his or her career, slaying the dragons but making a name for themselves and earning all this money, how fair is that when the one was backing that person up and they don't get to share in that success?
Right. No retirement, no pension.
Yeah. So it is relevant today, and stuff. And that's how I came to terms with it. It's about the relationship, it's about sacrifice on one hand, and the other person having the license to go out and self-actualize where the other person can't, and stuff. So interesting. I'm actually glad this decision is here because I think that. We've seen a lot of cases. I mean, a real lot of cases where women and men, but mostly women, are cut off from having any spousal support after lengthy relationships because of these type of provisions. I would have at least liked to have gone into court and said, hey, is this fair?
Right.
Okay, well, thank you, and we'll see you next time on Exhibit A.